Hello, this is Professor Jordan, and we're going to cover in Law 1, Business Law Contracts, assignment number 5, which is the case of MSI versus Brass. By the way, MSI is an employer and Brass is the employee. This is a case that occurred in 1993 when MSI, the insurance company here, hired Brass as an insurance agency, and on June the 21st, Brass entered into a career agent's contract. So you can see here that Brass here entered into a contract. And the contract contained provisions regarding activities after termination. This would be, in essence, a non-competition clause, and stated that Brass was precluded from soliciting MSI customers. In other words, they believed that the MSI had rights to its customers, and that Brass, after he left, could not go ahead and seek for a period of 1 year to get business from MSI or his MSI customers. He couldn't solicit the customers to lapse, cancel, or replace their insurance contracts. The contract also provided that Brass could not work for the competitor, American National, for a period of 3 years upon termination of the contract. So on December 30th, 1998, which would have been, I guess, 5 years after he had started working, Brass goes ahead and quits over here, upon which he starts working for American National. And at that point, on January 15th, 1999, MSI sues, claiming that Brass had violated the non-compete terms of the agreement, and issued a temporary restraining order from competing in any way with MSI. And then basically both parties went to court and prepared motions for summary judgment, and the court held in favor of Brass. Now, the reason that there's a Wisconsin statute which basically says that an employment non-compete clause, in order for it to be enforceable, it must be reasonable, cannot be overly broad, and must be reasonable as to time and geography. And the reason is because they want to promote, number one, the mobility of workers such as Brass here, able to leave and go work. Also wants to promote or prohibit a restraint of trade, and if the restraint of trade by MSI, that it's reasonable in terms of protecting the employer. Now, if you take a look at the case and you read it, you'll notice that the language says any MSI policyholder, known or unknown, was part of the agreement that he could not solicit. That could be in Wisconsin or the whole world, therefore very overly broad. And second of all, any type of employment, MSI, that Brass was precluded from seeking, which is totally unreasonable since he could work in some other area. So the thing to remember here, again, is for purposes of enforcement of a non-compete clause, it cannot be overly broad as to time and geography. Otherwise, as in this case, the court can hold that it's void and unenforceable. So that's it. Go ahead and look at the questions in the case. Make sure that you answer all the questions. And again, just to summarize, Brass won because the contract with the non-complete clause was overly broad, unenforceable, and contrary to the free process of trade. Hope that helps. Bye.